Have you ever downplayed your skills or maybe, deliberately underperformed on a test just so people wouldn't expect too much from you in the future?
Oh, yeah. I think we've all been there.
Right. You know the feeling. You lower the bar intentionally so you can just comfortably clear it later without breaking a sweat.
It's a surprisingly common human instinct, honestly.
It really is. Like, we do it to protect ourselves from the pressure of high expectations,
Right.
or maybe out of some twisted form of imposter syndrome. But when that exact same instinct finds its way into law enforcement, specifically into lethal force and firearms training, it stops being a harmless psychological quirk.
Yeah, it becomes incredibly dangerous.
Exact.
Mutates into this massive systemic liability,
Mm.
and that puts both the officers and the public at extreme risk.
Which is exactly why we are tackling this today. The mission for this deep dive is to completely dismantle a really toxic piece of training room folklore.
And we've got some great source material for this.
We do. We're pulling directly from a fascinating and frankly alarming article published today, March 23, 2026, on the Valortech blog.
Right, by Herfel.
Yeah, her fella. He's a 30-year veteran firearms instructor and a competitive shooter. And he is taking direct aim at a practice that sounds, almost too absurd to be true to anyone outside this specific profession.
But it stubbornly persists.
It does. So what exactly are we looking at here?
Well, to give you a clear overview, in the law enforcement training community, this is known as the qualification score myth.
The qualification score myth.
Right. It's this widely circulated, really persistent belief among some police officers that they should intentionally avoid shooting a perfect score on their mandatory firearms qualification tests.
Just let that sink in for a second, because I had to read that twice when I was going through the source material.
It sounds crazy, right?
It really does. We are talking about individuals who carry lethal weapons for a living, standing on a range, shooting at a static paper target, and actively trying not to be perfectly accurate.
Yeah, they are deliberately pulling their shots into the outer rings.
And why? Like, what is the motivation there?
It's entirely rooted in fear, honestly. The myth claims that if an officer shoots a 100% perfect score on the range, a plaintiff's attorney will inevitably weaponize that score against them later.
In like a civil rights lawsuit or something.
Exactly. Or a criminal trial.
Mm.
The fear is that a sharp lawyer will hold up this flawless piece of paper to a jury and demand to know why, if the officer is such a perfect marksman, why did they miss their target in a real-life shootout?
So they think a perfect score is a trap.
Yeah, they somehow convince themselves that a slightly lower score, say an 85% instead of 100, gives them breathing room in court to make mistakes.
Okay, let's unpack this, because to anyone sitting at home or working a civilian job, this sounds completely backwards.
It really does.
It sounds like a straight-A student deliberately bombing a midterm exam just so the teacher doesn't expect them to ace the final.
That's a perfect analogy.
Only instead of a grade on a piece of paper, we are talking about public safety, split-second life and death decisions, and, a loaded weapon.
Right. The stakes are as high as they get.
So the guiding question we really need to answer here before we even get into the physical danger of this is, does this twisted self-preservation logic actually hold up in a court of law?
The short answer is a definitive no.
I figure.
But to understand why, if we connect this to the bigger picture, we have to look at the actual legal battlefield. We have to strip away the locker room rumors and look at what courts and juries are legally required to evaluate.
And what's that?
Well, courts simply do not punish documented excellence.
The Valortech article makes a huge point of this, right? The entire myth assumes that a jury or a judge is going to compare a life-or-death shootout in a dark, raining alley to a sunny, quiet Tuesday at a static shooting range.
Point by point, yeah. Which is a fundamental misunderstanding of the legal standard for use of force in the United States.
ASAP.
Well, the controlling federal case, which has been the absolute bedrock of this legal doctrine since 1989, is Graham v. Connor.
Graham v. Connor, okay.
Right. That Supreme Court ruling threw out the idea that you can judge an officer's actions using 20/20 hindsight. It established that a use of force incident must be judged on a standard of objective reasonableness.
Meaning the court has to, conceptually put themselves in the officer's shoes at that exact terrifying moment.
Precisely. The court is looking at the context.
Okay.
They're evaluating the threat perception, the severe time pressure, the lighting.
The movement.
Exactly, the movement, the utter uncertainty of the situation. The law actively demands that the jury ask, was the officer's conduct reasonable given the absolute chaos they were facing in that fraction of a second?
And that's still the standard today.
Oh, absolutely. The Supreme Court actually recently reaffirmed this in 2025 with Barnes v. Felix, stressing that you have to evaluate the totality of the circumstances.
Wow.
And nowhere in that legal framework does a judge ask, was this officer too good at their job on qualification day 6 months ago?
Wait, let me make sure I'm wrapping my head around the real liability here.
Sure.
If I'm a plaintiff's attorney building a massive civil case against a police department, I don't care that an officer is an Olympic-level marksman on paper. I'm actually looking for the exact opposite, right?
You are.
I'm looking for the department that handed a gun to someone who barely scraped by with a 70% passing grade.
Yes, you are looking for a legal concept called negligent entrustment.
Negligent entrustment.
Right. If you look at Florida law, and Herfel uses Florida as a primary example in his breakdown, there's a pivotal case from 1997 called Kitchen v. Kmart Court.
Okay.
Negligent entrustment isn't about someone being overqualified. It is the legal liability that attaches when a dangerous instrument, like a firearm, is placed in the hands of someone who is known to be an unreasonable risk.
So if a department is knowingly putting an officer on the street who struggles to hit a stationary target,
The department is actively creating their own liability.
wow. And that scales up to the federal level too, right? With the failure to train doctrine.
Yes, exactly. Established in the city of Canton v. Harris, the Supreme Court ruled that a municipality can be held liable if their failure to train amounts to deliberate indifference to the rights of the people the police encounter.
Deliberate indifference. That's a heavy phrase.
It is. When an aggressive plaintiff's attorney sends over discovery requests, they are hunting for poor training records. They want to see inconsistent qualifications.
I want to see ignored deficiencies.
Exactly. They're looking for a paper trail of manufactured mediocrity because that proves deliberate indifference.
But I have to play devil's advocate for a second here.
Go for it.
Let's put ourselves in that courtroom. If an officer really does shoot 100% on a sunny day at the range, and then they find themselves in that chaotic, dark alley and they miss their target completely,
Yeah.
an aggressive lawyer is still going to point that out, right? They are going to use that gap between the perfect range score and the real-world miss to make the officer look reckless or panicked to a jury.
Oh, a plaintiff's attorney will absolutely attempt to make that rhetorical argument. It's their job to paint a picture of recklessness.
Right.
But that is exactly where a competent legal defense pivots. They rely on the hard science of human performance to explain why that gap exists.
Okay.
And critically, if the officer has a high baseline score on paper, that scientific defense is actually much stronger, not weaker.
Here's where it gets really interesting, because we are moving away from legal theory and stepping right into human biology.
We are.
We're talking about the unavoidable physiological reasons why those misses happen in the dark alley, regardless of what happened on the qualification range.
This is really the turning point of the whole analysis. You have to understand that a qualification course is a sterile, controlled environment.
Right, the paper target isn't shooting back.
Exactly. The lighting is usually adequate, your heart rate is normal, and you know exactly when the buzzer is going to go off.
Yeah.
But a real deadly force event is a massive biological shock to the system.
The Valortech article cites some absolute fascinating research on this. They reference a comprehensive review article called The Impact of Acute Stress Physiology on Skilled Motor Performance.
It's a great study.
It really is.
Yeah.
It details how the human body essentially hijacks itself when it enters survival mode. Like, we aren't just talking about getting nervous. We are talking about involuntary biological override.
The physiological realities are staggering, and they directly impair shooting accuracy. Let's look at the mechanisms behind this. First, you experience auditory exclusion.
Which isn't just tuning things out, right?
Yeah, not at all. Under a massive adrenaline dump, your brain's processing bandwidth is completely overwhelmed by the visual threat in front of you.
Right.
To cope, your brain literally stops processing audio signals. You stop hearing the sirens, the shouting, even your own gunshots, because your brain is reallocating all its power to survival.
And then there is the detail that completely blew my mind. Increased blink duration.
Yes, this one is huge.
Under extreme life-threatening stress, your eyes are closed for longer periods of time with every single blink.
Exactly.
Which means you are visually losing fractions of a second of the fight. It's like your brain drops the frame rate of your vision just so it has the computational power to process the visual data it just took in.
That's a great way to put it.
You are literally blind for longer moments while bullets are flying.
You are. And add to that the severe degradation of fine motor control.
Right, the adrenaline.
Yeah, when the body goes into fight or flight, adrenaline shunts your blood flow away from your extremities and towards your major internal organs and large muscle groups to prepare you to fight or run.
So your hands get clumsy.
Exactly. The intricate hand-eye coordination required to perfectly align the sights of a firearm and press the trigger smoothly without disturbing the weapon. That fine motor skill is one of the very first casualties of an adrenaline dump.
Because your hands literally lose their fine dexterity.
They do.
So a qualification score was never meant to be a combat prediction. It is in no way a guarantee of what you will do when the frame rate of your vision drops and your hands lose their dexterity.
Not at all. A qualification score is simply a baseline floor. It shows what you are capable of under ideal or, near ideal conditions.
Which brings us to the massive tactical flaw of the sandbagging myth. Think of your firearms skill like a savings account.
Oh, I like this analogy.
Right. A real-world gunfight is a massive, unexpected emergency expense that is going to severely drain your funds. Stress, fear, movement, poor lighting, blood shunting, these are all heavy taxes on your physical ability to perform.
Right.
If you know scientifically that this adrenaline tax is going to drain, say, 50% of your performance capability the moment the fight starts, why on earth would you intentionally start with a smaller bank balance?
You wouldn't, because if you artificially lower your starting balance to 75% just to look humble on paper, and then the biological tax hits, you drop to 25%.
And at 25%.
You are no longer effective. You miss your target, and you become a lethal danger to yourself and innocent bystanders.
You want to walk into that alley with 100% in the bank, so when the biological tax hits, you drop to 50%, which might still be just enough to survive.
Exactly. Deliberately scoring lower shrinks your margin of safety.
It does.
And the Valortech article actually backs this up with another study, Training with Anxiety. Short and long-term effects on police officers' shooting behavior under pressure.
Oh, right, the anxiety study.
Yeah. The researchers found that training that actually induces anxiety reduces the deterioration in shooting performance later on.
That makes perfect sense.
It proves that a higher baseline skill, constantly maintained and combined with stress exposure training, creates a larger performance reserve. You have to build the highest floor possible because you are guaranteed to fall down to it.
It's not just a bad legal strategy. It is quite literally operational stupidity.
Yeah, it really is.
But, we are putting a lot of this on the individual officer's mindset. I mean, a scared rookie falling for a locker room myth is one thing.
Sure.
But if I'm on a firing range, deliberately throwing my shots into the dirt to lower my score, an instructor is standing right behind me with a clipboard watching me do it. So how does an entire agency command structure let this slide?
This raises an important question. And it is the exact angle a shirt plaintiff's attorney is going to attack if this ever comes to light in a lawsuit.
Because it's a systemic issue.
Exactly. We have to shift from the individual officer's physiology to the profound institutional rot that this myth creates.
Because instructors are signing their names at the bottom of these artificially lowered scorecards.
Yeah. When an officer carries a firearm, they do so under the authority of law. And that authority comes with a profound ethical and professional duty to be as absolutely competent as humanly possible.
I want to walk through the brutal deposition scenario that Herfel paints in the article because this makes the institutional danger so clear.
It's a terrifying scenario for any department.
Right. Imagine the plaintiff's attorney pulling up the training record in a deposition after a controversial shooting. The officer's on the stand, under oath. The lawyer asks, "Why did you only score an 85% on your last qualification?"
Yeah.
If that officer has to admit, under oath, that they were actually capable of 100% but artificially lowered their score for litigation optics.
It is a catastrophic moment for the defense.
And it has to be.
Because instantly, the entire narrative of the trial shifts. It's no longer a scientific, biological debate about whether the officer's performance in the alley was degraded due to acute stress.
Right. It stops being about the biology.
Exactly. The narrative becomes about a fundamentally dishonest training culture.
It proves to the jury that the agency prioritized imagined courtroom optics over actual public safety.
Yep.
It basically tells the jury, we were more worried about getting sued than we were about making sure our officers could shoot straight to protect the public.
And no serious trainer, and certainly no defense attorney, ever wants to defend that position. It suggests that official government records are being manipulated.
Which is awful.
It signals incredibly weak instructor leadership and deep institutional insecurity. When an agency tolerates sandbagging, when the instructors just sign off on a manufactured 85 instead of 100, they're signaling to every officer that the standard doesn't actually matter.
It is the definition of a fear-based culture.
It is.
And the law actively demands the exact opposite. The Valortech article points out that Florida's regulatory system, for example, is built entirely around honest, rigorous documentation to prevent this very liability.
Yes, absolutely.
Yeah.
Florida Statute 943.1735 explicitly demands basic skills training related to use of force and policy.
Okay.
And beyond that, the Florida Department of Law Enforcement, the FDLE, has strict mandatory retraining requirements. They require education on the legal aspects of force, scenario-based training, and crucial education on those exact physiological stress responses we just detailed.
So they want this documented.
Yes. The state creates these statutes to ensure agencies are building highly competent officers, not manufacturing mediocrity to hide from lawyers.
From a legal defense standpoint, think about how much easier it is for an agency's lawyer to stand up in court and say, look at these meticulously honest records.
Exactly.
Our officer was highly trained, consistently documented at a 100% standard of excellence, and fully prepared. But on that night, they had to react in a chaotic, high-stress, rapidly evolving event where the uncontrollable realities of human physiology took over.
That is a highly defensible, scientifically backed position. It sounds like a highly competent professional agency that trusts its own standards.
Right.
Compare that to the alternative. Well, we intentionally avoided documenting our officers at their best because we were afraid excellence might be misinterpreted later.
That sounds terrible.
You do not protect officers by teaching them to look worse on paper. You protect them by building a standard high enough to survive the physical and mental collapse that real lethal stress inevitably brings.
So, what does this all mean? If we zoom out and look at everything we've covered from Herfel's breakdown, this qualification score myth fails on every single conceivable level.
It is a complete and total failure across the board.
Let's do a rapid-fire recap. Legally, the myth fails because courts judge use of force based on objective reasonableness in the fraction of a second the event occurs, not on a demand for paper target perfection in hindsight.
Right.
Tactically, it fails because real-world stress massively degrades human performance, your frame rate drops, your fine motor skills vanish, meaning you need the highest biological baseline possible, not an artificially lowered one.
Exactly.
And professionally, it fails because sandbagging is a betrayal of readiness. It infects an agency's culture with fear, dishonesty, and institutional rot.
Documented excellence is your ultimate protection. It is never your exposure.
And bringing this back to you, the listener, even if you never wear a badge or carry a firearm, the core lesson here is deeply universal.
It really is.
Whether you are managing a team in a corporate environment, learning a complex new technical skill, or prepping for a major high-stakes presentation, never, ever artificially lower your documented standards just because you fear the weight of future expectations.
It is a false shield that will eventually shatter.
It really is. Pretending to be mediocre doesn't protect you from criticism. It just normalizes weakness. It shrinks your margin of safety and makes you incredibly vulnerable when real pressure finally hits. Honest documentation of your absolute best effort, your excellence, is your armor. Wear it proudly.
That is a vital takeaway. And it leaves us with something really profound to consider regarding how we judge human action after the fact.
What's that?
Well, we spent a lot of time today dissecting those physiological responses to lethal strikes. The brain reallocating power to cause auditory exclusion, the loss of fine motor control, the altered blink duration dropping your visual frame rate.
Right.
These are automatic, uncontrollable biological reactions to sheer terror.
It's the human body aggressively taking over just to keep you alive.
Exactly. But it raises a question that stretches far beyond just police training.
Okay.
If our bodies fundamentally hijack our senses during a split-second life-or-death encounter, drastically altering how we see, hear, and move, what other automatic human stress responses are happening in those terrifying moments of crisis that our legal system and our juries still fundamentally misunderstand or completely overlook when they are trying to judge reasonableness from the quiet, air-conditioned safety of a courtroom?